This is a criminal law lecture in relation to offences against the person. Now, offences against the person is in fact very well established for the last 2 centuries or so, and it's still founded on the Offences Against the Person Act 1861. The only thing I would say about the Offences Against the Person Act 1861 is that it doesn't actually create a coherent set of offences, and there have been many problems in the law. And in fact, the Law Commission has proposed countlessly a complete reform of the law, but still has not reformed the law in this regard. Now, I'm going to deal with the various offences against the person as they are actually known. I'm firstly going to deal with common assault, then I'm going to deal with assault occasioning actual bodily harm, and then malicious wounding or inflicting grievous bodily harm, and then finally wounding or causing grievous bodily harm with intent. These tend to be the 4 main types of offences. So when we deal with common assault, there are 2 subdivisions of this. There is number 1, assault, and number 2, battery. Both these offences are now charged as amended under section 39 of the Criminal Justice Act 1988, and are both summary offences. Again, as with criminal law, we have to prove both the actus reus and the mens rea. If we deal with assault first, the actus reus is something that is quite straightforward to understand, but what we should first say, that assault is also known as technical assault or a psychic assault. The defendant intentionally or subjectively recklessly causes another person to fear immediate unlawful personal violence. So what is the actus reus for an assault? Well, Fagan against Metropolitan Police Commander tells us that it requires some act or words, and omission is not enough. The case of Ireland says that words are sufficient for an assault, even a silent telephone call can be an assault. And the case of Tuberville, Tuberville, against Savage, tells us in fact that words indicating there will be no violence can prevent an act from being an assault itself. This is a recorded tutorial for contract law, the law of misrepresentation. Misrepresentation is a vitiating factor in contract law. It occurs where representations have been made before the contract has been formed, and those representations allow for the formation of the contract and for those representations to permit a person to enter into a contract. There may be mere representations which are made on their own, and these really do not have any contractual significance. They are merely used to induce the other party to enter into a contract. But if they are accurately stated, they do not create any liability. It is only where there is a falsely stated or inaccurate representation made which makes the representation actionable. Now, the motive behind the inaccurate representation is not vital to establishing that a misrepresentation exists, though it can be critical to determine the class of misrepresentation and then the remedies available. If misrepresentation is established, then the contract is voidable, and the victim of the misrepresentation may avoid his or her obligations under the contract, or they can have the contract set aside. Now, this has a number of practical considerations. Number one, traditionally, there were no remedies available, so it was vital to prove that the false representation became a term of the contract. Number two, misrepresentation can be said to be a new class of action, one which is now created in statute. Although this tutorial is in relation to the issue of land law and that of adverse possession. It's pretty well known that once you've purchased property according to the legal formalities and rules, you're recognised by the law as the legal owner. This should mean that you can be reassured that the only way the legal estate will pass into the hands of another person is if you take the initiative by either selling the property or giving the property to another during your lifetime, or even leaving it to someone under your will. You might even be giving it away during ownership through having it mortgaged, for example, with a mortgage company or bank, or even creating a legal lease. So the well-known way in which you can give up the land, of course, is that if you don't repay the sums borrowed, for example, on a mortgage, the mortgagee or the lender has the right to take possession of that property. But as far as adverse possession is concerned, that's not the full story. Because in certain circumstances, someone whom we might regard as, say, a trespasser on the land, with no legal rights at all to be on the property, can simply lay claim to rights of possession over your land if they satisfy certain conditions. It's been come to known as the most legal way in which you can steal property or steal somebody's land. Now, it's important to look at the Limitation Act 1980, because the law has long recognised the rights of others to take over your property if you, as the owner, do not assert ownership over a long period of time. So we can own personal property such as valuable paintings and leave it in a blank vault for years, but it will not undermine its actual ownership. Land is treated, of course, quite differently, because you can't lock it away in a bank vault. It was thought that land, obviously for these purposes, is too valuable, or was too valuable, to actually in fact ignore it. So the law, therefore, in land law anyway, has recognised the rights of others to come and take over the land or the property, and if they treated it as their own for a long period of time, then they could claim it for themselves. And the law refers to those persons as what we call squatters. They are strictly trespassers until they satisfy the conditions required to claim the actual title of the land. An interesting case of RB policies at Lloyd's against Butler comes up with this phrase, quotes, "Those who go to sleep on their claims should not be assisted by the courts in recovering their property," close quotes. This is a tutorial stroke lecture recording in relation to company law, and more particularly the issue in fact of capital. The areas that we'll be covering in relation to capital are the nature and allotment of shares, the nature of loan capitals, for example debentures, and how we register charges, the maintenance of capital, and class rights. This tutorial will also go on to further discuss final issues in company law to do with company failure and liquidations, looking at the legal framework, the pre-insolvency procedures, winding up, fraudulent and wrongful trading. Now, turning back to the issue of capital and the nature of shares, we see that a company can raise capital either by issuing equity securities such as shares or by in fact borrowing. Shareholders undertake to contribute an agreed amount of capital to the company, and if the company is limited by Hello there, this is a recording in relation